Hello, welcome back to Rigged. I'm Jamie Folk. We have some important new documentation that Chris has obtained. Chris, here I'm going to start sharing my screen and we can talk about these documents that you obtained from. You want to talk about their background first, and then we'll just,
Sure,
yeah.
and it's really important to mention that these are all redacted. So there have been multiple protective orders in place um, that were ordered by Justice Hagan of the Middlesex County Superior Court. Yesterday, he lifted the most recent one about 24 documents that the Inspector General's office had turned over to us on October 24th, 2024. So we looked through those, and in short order, we realized there was tons of Brady material that we hadn't seen before. And we brought that to the judge's attention. And after a fairly lengthy hearing, um, he didn't rule on whether or not it was exculpatory or not, but he did rule on whether or not there was good cause to keep the protective order in place. But he did want to make sure that, given the fact that we're having an evidentiary hearing coming up, probably in February or March of next year, that every single name that wasn't included in the original OIG's reports should be redacted so that there's no witness tampering, no reporters calling people working from the OIG or anyone else. Anyone who was in the original reports is fair game, but everyone else, just to make sure that the hearing is fair and goes smoothly and everyone testifies truthfully, we had to heavily redact these. So, that being said, I think today we're going to discuss three of the documents that we received. The first one, I think, is fairly interesting in that one of the OIG staff members indicated that he or she believed all the cases should be dismissed because the
Right.
testing and testimony was unreliable.
It
So if you
says right
want to,
here, so this the what you're referring to, Monday, March 22nd, 2021, internal OIG email. I am sure you have seen the news that DA Rollins is seeking to dismiss all drug lab cases. I have attached her office's filing and press release. And then the response, Tuesday, March 23rd at 7:55 a.m. Wow, and finally, seems like the right answer to me. Radical, I know. How is that radical? Although no bad actors other than Dukin could be found, not true. How could the testing testimony be reliable? Question mark. Abject, perfect word to describe Hinton.
so the abject part that comes from DA Rollins's press release. But what's interesting about this, again, this is post multiple reports where the OIG or the IG himself has said Dukin was the sole bad actor. Still, people in his office think that all of the Hinton Lab cases should have been dismissed, not just Dugan, not just Farrick, everything. And
Yeah.
why? Because the testing itself and the testimony of the chemist could not be reliable based upon what was found by the OIG.
And plus they're such liars. Like they you don't there's no way to know the extent of their malfeasance. Period. Because they were all over the map, and Dukin was shown to tamper with other chemists' sample or take whatever sample she wanted out of the safe. You cannot trust anything she was doing in that lab at all, and anyone else's because she was forging people's initials. She was doing all like there's so much in
Well,
there.
forget
And
about Dukin. They referred like half a dozen chemists
yeah,
for
Della
to the
Saunders.
AGO for criminal prosecution because of willful violations of the law. If you go back to the referrals, the
Yep,
specific language is willful, right? They knew what they were doing.
right. And it seems like it was policy to me, at least with some in the lab. I'm sure the Charles Salemi of the world and those guys would disagree, but there wasn't control at all. And I mean, motive. What were they trying to do? Why were they willfully breaking the law?
Yeah, I mean, so there's two different questions. One is why are the Hinton chemists doing that?
Yep.
And then why isn't the OIG making that public? Right. So there are all sorts of emails that we've discussed in this podcast where it's very clear the mens rea of the chemists. We talked about that in one of the preceding two episodes, and they just are silent about that in the report. They leave it up for grabs whether or not it's negligence, some sheer accident, whatever. But here we see as far as late as March 23rd, 2021, someone is saying, the testimony isn't reliable from these chemists.
And it's worth pointing out that the OIG's sort of official position has always been that it's only a select number of samples
Hmm.
that have problems, right?
Aliquots,
We
remember?
we'll tell you the good ones and we'll tell you the bad ones, and we can tell the difference. And notwithstanding, at least my understanding that the OIG was supposed to investigate anything and everything that smelled bad, they chose, and we'll get to this a little more, but they specifically chose only to look at samples that had been tested multiple times, and then for retesting, and then based on the retests, decided that, oh, it's only a very small number of miscarriages of justice, so nobody has to worry their pretty little heads about this. But the reality is that that's one fact pattern, the multiple testing. But there are other fact patterns. There are undoubtedly instances where the test was done once, but it was flawed and unreliable, or there was willful misconduct, or there was misrepresentation of credentials, or lying about compliance with swig drug, or in-house cooking of the standards, all kinds of stuff, or fishing things out of the trash.
Quote,
I don't want to forget that.
nefariously
My
spiking a
favorite.
sample was one
Right.
of the quotes from one of
So
your.
so it's
Yeah.
funny that when the guard is down, I'll note, by the way, this is about a year into this podcast's existence, this email, right? So we had been at it for about a year, and now finally, apparently the coast is clear to stick your neck out and say, well, yeah, all these cases should go away. But that's not the position that the OIG had taken in their official reports.
No, no one's saying that out loud. And Ilias, the one thing, like you listed a lot of the malfeasance, and that's great, but the thing that always gets me is the turning negative into positive. Why the fuck, if like the whole everything that we've, all the official words, she's rushing, Annie Dukin was rushing, all these people were rushing. Turning negatives into positive is a whole different thing. And that you lock that in with knowingly misclassifying drugs to send people to jail
With a
for
whole bunch of
possession
other
of drugs that
chemists.
weren't illegal.
Yeah.
Right.
Like those
And I
two,
think
like they're sending innocent people to jail, guys.
Right.
Like
And I think
knowingly.
we've covered the fact that at least in certain cases, even whether when Annie Dukin was involved, because she's the only one that we've sort of looked at as closely, but when there was um, a turning a negative into a positive, it actually looked like it was more work.
Right.
So it
It
can't be
was.
explained by rushing. It actually was
Yeah.
more work, right?
Yeah. You
You
had
have
to
to
take
like
the cocaine out and you also put yourself at risk. Like there's a
Right. You had
lot.
to tape cardboard to the side of your workstation so no one could see. There was things you had to do. She would use that standalone GC machine, which is
Yep.
not part of any workflow in that office as I understood it. And then there was that funky sample, or it was a sample sheet where it was everyone's problematic, and I assume negative samples got kind of thrown together for retesting. And that's never made sense to me. If a chemist is assigned 40 samples, why are you splitting some off for one secondary chemist, and but others go someplace else. Doesn't make sense.
No.
Unless you knew that the positives went one way, the negatives went another, and you're trying to do something.
And
You're
dude,
trying to do something with the
what
negative.
what did we
Well,
see time and again? I'm sorry to cut you off there. What did we see time and again? Anytime it was negative, it got retested and
I,
retested.
I think there's enough that we have in the next document to forget about speculation. Uh, we can just go right into what the OIG staff members said that they thought. Um,
Draft of Sutton. The name of this is OIG 2019 Draft of Sutton Filing.
okay.
so this comes from the case of Commonwealth v. Eugene Sutton, and at this point in time, there was a filing between or in front of the single justice of the state Supreme Court, and essentially, what we want to look at here is the fact that proposed language about Dukin being the sole bad actor is commented on, and ultimately they withdraw that from this filing. But later on, it's the same language is used again in a publication in 2021. But it's interesting if you are looking at what's on screen now. Uh, there are two comments on the phrase or the sentence. It further found that and then crossed out, Dukin was the sole bad actor. One comment says, put in more specific language. Uh, she was the sole bad actor, meaning dot, dot, dot. And then the second comment there is more interesting. Do we want to repeat this? Put in context. And then if you scroll down to the second page, there's another comment where it says, after the sentence, it then laid out its findings in the 2014 Hinton report. Uh, One member of the OIG staff commented, at the end of the previous sentence, should we add a footnote regarding our referrals to the Attorney General's office?
Uh,
Right? So at this point, no one knows except the Inspector General's office and the Attorney General's office that other people at the Hinton lab had committed willful misconduct.
so that sentence says, the one that you just read that comment for, it
Mhm.
says, and while the OIG met with a wide range of stakeholders during its review, the OIG did not take direction from or conduct any work on behalf of any stakeholders, including district attorneys.
Mhm. Well, I think the comment said at the end of the previous sentence, so that's what it's speaking to about laying out its findings in the
Oh, it
2014.
then laid out its findings in 2014 Hinton report.
Yeah.
And that's what they wanted.
So,
Okay, so they said and. All right.
so,
So could we
essen-
just give a little context here because I think people might be excused for not remembering. We covered Sutton
mhm.
previously.
The big issue here was whether or not the Inspector General's office was part of the prosecution team, and therefore whether or not Brady material, meaning exculpatory evidence, was required to be disclosed to the defendant in that case and other similarly situated defendants.
Right. And by
And
this point, this is 2019. So a bunch
right.
of people who had their samples tested by Annie Dukin had already gone through the court system and
Hmm.
either got uh, new trials or had their convictions sort of taken away. Then you had a group of people like Sutton who didn't fit into any particular category,
Hmm.
who of relief, who, and credit to you and Jim McKenna and all the attorneys who have been fighting this case, created their own categories on the fly, and said, you got to pay attention to the facts of this case because there's still problems. So 2019, this is after the OIG had done its two principal reports.
Yeah,
And
I think more specifically, this is interesting. A nice side note. But the cases that opened the door, so to speak, were the Farrick and Hinton ones. Because when we were originally dividing up the cases, originally it was Annie Duke in the primary, was Annie Duke in the secondary, and we were arguing about which one was more important. And then the Scott decision came out and said, if she's on the cert, doesn't matter, presumption of egregious governmental misconduct. So we said, okay. And then after
The only
that,
way to handle it.
we divided things up into whole lab claims, meaning claims that involved a chemist other than Dukin and other than Sonia Farrick, and then two other categories, subcategories of that that looked promising at the time, but we hadn't fully developed. The Farrick at Amherst cases, along with the Farrick at Hinton cases, and then the Saunders cases, and then everyone else. And this was because of the testing volume of each chemist. Those were repeatedly the highest producers in the lab, and the results seemed totally impossible. So after all the litigation out west with Farrick and the Amherst lab concluded, we were left with Farrick at Hinton and then everyone else. And so we were looking at those Farrick cases and then particularly Saunders ones, and then any particular case that looked odd because of the lab packet. We pursued that for a long time. And Sutton was, if my memory serves correct, one of the Farrick ones, where Jim was arguing in Cotto and Ware, the SJC said there's a constitutional obligation for the government to conduct a thorough and adequate and timely review of her work at the Hinton, or all of her work, given what we now know about her. And he was making the point that hasn't happened. And then a certain point of time in Sutton, there was a question about whether or not the OIG had any files about Farrick in their possession. They fought that like mad in order to try and stop the defense bar and also stop the district attorneys from getting access to their files. And then eventually the trial court ruled that they were part of the prosecution team because of the peculiar circumstances of the case, where normally it would be a district attorney's office handling this. Then the attorney general's office took over. And then after they were conflicted out because the AG's office had cases coming out of that lab, the IG's office took over. In those particular circumstances, they're part of the prosecution team. So all their files, anything exculpatory in it, should have been turned over.
And who used to run the OIG? Where did he used to work?
Glenn Kuhn,
Yeah.
before that, he was at the Attorney General's office.
Oh, weird. And then Norfolk County before that, right?
Can't quite remember, but yeah, it was really odd that he was in the same bureau at the AG that was dealing with this before it got handed off to the department that he later became in charge of.
Right.
So is that a good enough of a recap?
Yeah,
Or?
and I'll just add one thing, which is that the references to Farrakh at Hinton
Mhm.
is, again, this is going back into the past, but it's indicative of the fact that Farrakh actually started at Hinton and for some period of time worked with Annie Dukin,
Mhm.
which makes one imagine what their informal daily conversations were like before she was transferred to Amherst, and then I guess that it's at that point that she became addicted to crack and
Well,
started.
we knew that she was a marijuana user frequently before then and had also dabbled with cocaine and heroin while at grad school before dropping out. Uh,
Wasn't she asking for cocaine samples at
well, what was interesting, we don't know that she was specifically asking for them at Hinton. We know that she was in Amherst, but what really was a turning point when we had a statistician look at the numbers, and we saw that when Farrick was at Hinton, she did more cocaine samples per month than any other chemist in the history of the lab, including Dukin, by
Yeah, I
a
wonder.
shit ton. That raised some red flags.
Well, and then remember she was unceremoniously booted, right? Like there was a meeting and then she was gone after she had like a crazy month of sample results or of testing. It was off the charts and they yanked her in and sent her packing to Amherst, right?
Yeah, there was a incident involving a circumstance where someone labeled something as, or printed a drug certificate indicating that evidence sample was cocaine when it turned out to be heroin. And we've been trying to figure out who that chemist was. Based on the numbers, it looked like it was either Ferrick or Saunders, and it couldn't have been Dukin because she wasn't running those machines at that time, at least according to the evidence database. And we're actually still waiting for discovery on that.
Hmm.
One
Oh,
of the other things that we received recently, um, I guess this has been, the protective order has been removed. So in one of them, there's a discussion, a draft that I haven't sent to either of you two, where they talk about the corrective action report and how they actually found the sample number and the chemists and their experts look at it. But we don't have that sample number. We don't know the name of the chemist
wow.
yet.
Well, I'm sure there's
Well,
nothing to see there.
Probably not.
neither of those names would surprise me, but I know that there was a meeting and Sonia like left shortly thereafter. I
Right. It was
remember
like a
reading
couple months
something
later.
on here
Yeah.
or writing about it. Yeah.
But that's still in the realm of speculative, right? That's interesting, but not
It's just
something to weigh a
astounding that
jury.
there's anything that's not been made public. I mean, to me, that's what's astounding. I mean, we're
Year 12.
year 12 and none of practically none of these people still work in the same jobs that they held at the time.
Yeah.
Jim McKenna keeps saying if this case was a kid, they'd be starting high school.
Right.
It's true. And dude, I asked the Department of Public Health, I'm like, can't you just give me the database at this point? Like,
Yeah,
why does it matter? And they're like, no, we have to redact everything. We have to redact, and we have to pay someone to review the records.
yeah.
It's like, dude, it's been 12 fucking years.
Well, let's move on to the meat and potatoes or
Yeah, all
the
right.
icing on the cake. What's come about 12 years of litigation is the most impressive thing, I think, is the next file that we're going to talk about. It is a draft of the OIG's 2021 report where they're defending their methodology and explaining what they did in their first two reports and confirming or stating that
Dude,
Jukin was the sole bad actor.
seven
And
years later, they're
it
like,
is
hold on,
littered with
guys.
comments from OIG staff essentially saying, and we're going to go through it, I'm paraphrasing now, but essentially saying that's not accurate, right?
Right.
So let's start going through these.
And before you start 2021, what's this OIG? Who's going to read this OIG report? Who's the audience?
Well, this came after, you might recall, there was correspondence back and forth between the Middlesex County DA and Glenn Kuna, where she was calling for an explanation, and then he was being really catty and bitchy about the fact that she was calling him out. And then this was the result of all that.
Okay, so this was a report meant to sort of allay concerns,
Yeah.
anything that's happened previously.
hmm So interesting stuff. I'm just looking at the screen that you're sharing on page one. Um, one of the comments. Okay, so let's look at this. One sentence in the draft reads, um, the OIG has made its confidential hint and drug lab files available to prosecutors to examine for potentially exculpatory evidence for defendants, as well as to understand the scope and depth of the OIG's investigation. Someone commented, redacted, what about the referrals? Yeah. uh, and then also, there's an additional comment about, are we not including this? Because one angle is it didn't impact the testing, which we'll see later on other people disagree with, but the rest of the comment reads, Wouldn't this help us if we mention that we did send referrals, etc.? And then further on down in this one, uh, there's indication that the OIG was aware that we were looking at Della Saunders too. And then there are a bunch of comments that were redacted, which I still don't know what they say. It could be formatting stuff. It could be directly related to Della Saunders. I don't know.
Well,
Don't want to
nothing has
speculate.
ever Delisandro's name. This is the first I've seen of her being. I've seen a lot of them, but Delisandro's she was kind of brought up, right? I
She
think.
Yeah,
was
I mean, we
she
were
was
principally worried about her testing numbers.
Right.
And we were just like, okay, I mean, it could be she's dry labbing. It could not be. Did you ask her about it? And like, if no one has asked her about it or looked into it, don't you kind of think you should have? And isn't that a constitutional requirement?
Well, the state police did, right? They asked her
It
in their
was like
initial
there's a 2 or
investigation.
3 page interview,
Yeah.
right?
Yeah.
right. And what we found going through specific samples that were, highly suspect is that there was no requirement that Dukin, for example, was involved with the sample. There were many that where she wasn't involved. Sometimes she was primary, I think sometimes she was secondary.
Mm-hmm, mm-hmm.
And there were some sketchy samples. I think there was one that I recall with Della Saunders. There were some others that you couldn't explain with just blaming Annie Dukin.
Right.
So I think that this is sort of a discussion that's operating on many levels. On one hand, there's the actual facts, okay? And I don't know if anyone has ever been able to go through everything and say, I know all the facts, but there are certainly other samples that should have been looked at, probably weren't. Then there's the practices that might result in those facts, but we have testimony admitting to certain practices either that were negligent because they omitted certain key steps or they were negligent bordering on reckless or intentionally wrong because they did things that weren't supposed to be done. And I've never seen any evidence that any one person monopolized any of that, right? So it's sort of like, I think everybody's fair game at this point to be mentioned.
Yeah.
Agreed. And so here's where it says,
Well, here's the good part in this one.
yeah,
Okay.
here, go ahead.
The proposed sentence in the draft, the OIG determined that Dukin was the only chemist that engaged in misconduct. One comment that we can see that was partially unredacted says revisit, which means there's a problem here. We need to talk about it. But the second one says also, what did we conclude? Did we find evidence of chemist misconduct? Maybe in the last paragraph. So that one's a little more ambiguous, but still a reference to the statement Dugan was the only chemist engaged in misconduct, and people saying we need to talk about this some more. And then next page, uh, it says in the proposed sentence where the OIG discovered misconduct by individuals, it detailed it in the reports. Someone says revisit this again. And then someone says, I'm struggling with this sentence. Um, Yada, yada, yada. We can read the whole thing to be fair. I think its point is to explain that we didn't include it if we were determined nothing was wrong, i.e., we did more than what was in the report. I wonder if this sentence makes an implication that if we did determine something was wrong, it would have been in the report. And then this is the important part. Obviously, there was some misconduct that we didn't include because we referred it.
Right. I mean, to me, that's maybe I wasn't paying close attention, but that's pretty shocking. Uh,
Right.
and I didn't understand, and maybe the listener has to sort of be reminded that the OIG was given, my understanding, a broad mandate to do a top to bottom investigation. And if along the way they found something worthy of a prosecution, they could refer it. I don't think that meant you get to stop what you're doing and delete any work product that you have. But that seems to be sort of the implication there, right? That if they made a criminal referral, they didn't have to include it in their report. But if you made a referral and nothing came of it, then you've sort of disappeared it, right? You've somehow contributed to the public not knowing about something that you were aware of, and you're supposed to report on what you're aware of. So that to
And
me is shocking.
they didn't just previously report to the Attorney General's office gross negligence or simple negligence or wanton or recklessness. It was willful violation of law, right?
No,
And
these are fucking chemists. Willful violation of law? Like, what the fuck was going on? What was going on?
but yeah, that one I think that sinks them for good. This one
Yeah.
sentence. Obviously, there was some misconduct that we didn't include because we referred it. I
Oh,
think that's the last nail in the coffin.
dude, and that I mean
Right.
that's their justification. That's what they're hiding behind.
Right. It would
It's
be
like,
obviously there was some misconduct that we included and we referred it. That's there. I fixed it for them.
yeah, like
Anyway,
why? Because you referred it, they're literally trying to throw the Attorney General's office under the bus. We referred it. That's on the ball's in their court.
Well, it's look, it's I hate to say, use the phrase cover up here, but if you go to page two, which you guys skipped over rightly to get to the good stuff, but page two has a section about policies and procedures. And I noticed, I guess maybe they didn't cross out swig drug, but they certainly eliminated what swig drug stands for in a place that you would expect them to say swig drug and define it, right? So in a weird way, all these edits, each one might be innocuous on its own, but the sum total of all these edits are to really minimize, right? To minimize, to not get you thinking about uh,
this
the implications of everything.
Well, it
this
says right
echoes.
there. Oh, go ahead.
No, you go ahead. Go ahead.
The OIG determined that Dukin was the only chemist engaged in misconduct, and there is redacted comments.
Right, saying obviously that's not true.
Yep. Yep.
Obviously.
And
What
then
I was
right
going to
under
say.
that, there's also revisit, and also what did we conclude? Did we find evidence of chemist misconduct? Maybe in the last paragraph.
Yeah, that's a little. It's a little vague. I think
Yeah.
it's clearly referencing some misconduct that the author of the comment doesn't think was clearly explained. But what's interesting about the swig drug stuff, this is the 2021 report, and if you go back to earlier episodes where we discussed this, they specifically removed portions from the original 2014 report about how the lab materially misrepresented its level of adherence to swig drug. And so the report itself that was published talked about all sorts of areas where they weren't compliant, but the materiality component where they knew what they were doing, they knew it was false, and told the world that they were following the standard when they weren't and knew they weren't, that was omitted from the first report, the second report, and the third report.
Right. And now this one says they didn't consistently adhere to swig drug minimum standards. And I think that is sort of a cop out because the first requirement of swig drug is to develop
Written policies and
policies.
procedures.
So I don't even see how you get out of the gate there. It's like,
Yeah.
the
Dude.
horse that doesn't move when the
The
gate.
horse scratched, right?
Yeah.
They're still in.
Pulled a hammy.
Yeah.
Dude, like, but the whole point, like, and training too, like, they had nothing. And the whole point of writing down, like I've said it before, I know it's boring, but you gotta write your shit down, or else you don't know what the fuck you're doing. You have to write down, okay, you turn on the machine, you press this button, you press this button. You have to have a standard by which your process should adhere to in order to do it consistently and robustly.
Right.
And the fact that they never had that is like I've worked for I've worked in the biotech industry for 20 years, if the FDA came in and we said, sorry, we never wrote SOPs for any of our processes, we have drafts though. They immediately grab a padlock, throw it on the front door, and say, this place is no longer manufacturing until we figure out like what's going on.
And can I just add a little color to people who are probably trying to picture what this document looks like? So this is a Word, I'm assuming it's a Word document
I'll
with
throw it on YouTube at
with
some point.
edits made in bubbles
Yes.
or comments
In the margin, yeah.
in the
Yeah, the
margins.
Word doc
And
with the comments
and
on
there are so many edits that the margin is almost completely full of bubbles. And the
it.
majority of bubbles are have been redacted,
Yes.
sort of CIA style, by the OIG's office.
Yeah.
And then there were some additional required redactions that had to
Yeah,
be
that
made
I put in.
that for names, etc. But
Right.
I just want people to know that like what we're reading is that which was able to slip through the otherwise very repressive redaction machine. And so one can only imagine how bad some of those other bubbles are that we don't get to see.
Like these huge ones right here, like this whole effing section.
You know, it's totally interesting. So they were required to give over 10,000 of these documents to the judge, and the judge was like, I only made it through a few hundred, which makes sense. Guys doing murder cases, you know. And then he issued an order, uh, you know, creating a subclass of documents that they had to send. They sent us these 23 in an index that have these heavy redactions. And as far as I know it, aside from the other few hundred pages the judge reviewed personally, we have no idea what's in the other stuff. So I had thought about asking for a special master to be appointed to look through it
Hmm.
all. But at this point, I think we've won, and we've got clients who are still in jail. Um, people facing collateral consequences, and enough's enough. When you get a comment saying like the one I described earlier, I think we're there.
Yeah.
What do you guys think?
I'd say so. When
Scroll
they
up
said
one
that
more time.
we knew that there was, yeah.
Yeah, scroll up one more time. I
Yep.
see. Yeah, up.
Yep.
Whoa, 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 down. There you are.
Obviously there was
Obviously, there was some misconduct that we didn't include because we referred it. I think that's probably going to be at the top of the supplemental motions for new trials for every defendant, and probably at the top of every SJC brief on this issue.
agreed. I mean, they're saying right there, obviously we didn't. Obviously. And then right underneath that is the best part. The creme de la creme for me. There's about a million comments,
Redacted stuff.
redacted comments on this paragraph. The OIG included all personnel, including short-term and temporary employees at the drug lab from 2002 to 2012 within the scope of this review. No employee was a specific target of the investigation, nor was any employee excluded from the investigation. This broad approach was necessary to determine whether there was evidence of misconduct related to testing that had not been detected or reported by lab management. Now, that
There were like
sentence,
six comment. I never picked up on that because I was going through what we saw in the comments, not the reference to the totally redacted stuff. But yeah, that's curious that there are so many
well,
totally blanked out. Yeah,
it's
go ahead.
when was Dukin, what was Dukin was there from 2003 to 2012, right?
I believe so. And then
So so they're
uh,
saying we didn't target.
Ferrick, Ferrick started, I believe, in 2002, if I'm not
Yeah, for some
mistaken.
reason I thought Dukin came
Dukin came a little bit after
a
Ferrick.
little bit after.
It's
So
been so
But
long that I looked at this. I think that's accurate, though.
but I mean that's those are only the years that those two were there. You know, it's like we didn't target this for anyone. We just randomly picked 2002 to 2012 as the years we're going to investigate. The years that those two chemists were at the lab. From the outset, the OIG was aware of specific instances of misconduct by Annie Dukin. This information helped to inform where and how a drug lab employee could impair the integrity of results, including testing misconduct, forgery of initials, chain of custody breaches, failure to perform calibration checks, false testimony, and general failure to comply with drug lab policies. That also gets about 5 or 6 comments that are redacted.
Yeah, I'm so curious. We don't want to speculate as to what that is, but
But that's a
uh,
shitload of comment. Like they're
yeah,
both those
that's
two.
not formatting, right? That's
No,
not someone saying
no, you
you
missed a
need to rework
period.
this sentence, put a comma somewhere else. This is like content stuff, clearly.
This is, I
And some of
mean,
these comments are like that looks like they're two that are like a paragraph long for
yeah.
sure.
And
And the other
that's
thing
for,
too is that, the headings, it's a little secret of lawyers that the heading is actually what you want the reader to take away.
Mm.
And then everything that follows is, might not even go in that same direction. So this section is supposed to be that stating a pretty obvious fact that misconduct impacted integrity of testing. But then this first paragraph seems like it's trying to protect OIG, right?
oh yeah,
Meaning
for
it's
sure.
saying that we didn't
Disclaimer,
have a specific target and nobody was ruled out and
right?
we
And then a bunch of
tried.
comments about all of that.
Yeah, and then an explosion of comments.
Right, and none of that has anything to do with misconduct. It has to do with the scope of your
Uh-huh. Uh-huh.
investigation, which apparently had limitations that were undisclosed.
Yeah. Well, they're saying it themselves.
Right.
Do we want to say misfeasance, malfeasance, because misconduct is a loaded term with legal implications, where a breach of policy and procedure could relate to reporting an OSHA violation or something like that? Food for thought. That's another comment when it
Yeah,
says
I mean,
misconduct.
so they're still going through semantics, right?
Yeah,
And what's important, again, we hammered this home to the judge yesterday. It's about Brady material. It doesn't matter if it's misfeasance, malfeasance, misconduct, whatever you want to call it. If it's evidence favorable to the accused, the defendant gets it. Period. Right? And they spend all this time arguing about semantics in
yeah,
order to protect their original conclusion in their report, even after there was a clear ruling from the SJC that they're part of the prosecution team.
yeah.
By this point in time, they absolutely should have known it doesn't matter whether or not our original report was right. We have an obligation to these defendants under the state and federal constitution.
Right. And they didn't want to ever get knocked off that original conclusion, which was, looks like was written sort of in advance, right? That was the conclusion. And then sort of like Casablanca, with Claude Rains,
Shocked to find gambling.
well, no, he's the one where he's like, I'm making my report out now. I haven't quite decided whether he committed suicide or died trying to escape. But it's like, you write your report, your conclusion first, and then you have to then include the facts that fit that. But the proper way to write a report is to write down all the facts, then read your report and see where those facts took you. And it would be very easy to correct your first report if that's the approach you employed. Because you could just say, oh, concluded sole bad actor in error. In retrospect, here's all of the bad actors. That would have been a very easy, I think, supplemental report.
So
Yeah,
And
one,
I thought you were going for the I am shocked to find out that misconduct is going on here.
no, no, but that one you could use all of it probably.
there's one big comment that's blanked out, and it's on a sentence that says the investigators reviewed the AGO and DPH Dukin investigation reports for any reference to misconduct or breaches of policy and procedure by any other chemist. Huge comment, blank.
Right.
Yeah, I'm waiting to see.
Wonder what that one
We can
says.
we can probably have another episode on the unredacted version of these.
Yeah.
Hopefully, it's
Are
interesting.
you gonna get one? Are you gonna
I
get
would
one?
bet you a Diet Coke that some of these paragraph long redactions are not just about formatting.
Yeah. Yeah, this whole page is I will post this on YouTube. I have to
Mhm.
post the last episode too. But this whole page here that we're looking at is there was the one comment that I read, and then everything else is blanked out. Everything. Everything. Look at this. There's like 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 comments. There's 14 comments total on the page, 13 of which are blanked out. Redacted.
And is that true that they tested? Oh no, sorry. Can you go back up? Who tested tens of thousands? That was the drug lab.
Where are
Um,
we
Were you
looking?
seeing
that,
that?
that so somewhere in here they say that they retested samples and it was a very small number.
I
They
can't
didn't.
remember the exact number, but it
Yeah,
was,
I
I
think
think
they
it was
said some.
definitely less than 2%.
Yeah, it was like in the hundreds.
Mhm.
And
Might have been a couple
I
that.
think it was like, well, somewhere it says like 609. And I remember we covered the math of how they got
In the
there.
earlier episode, yeah.
And one of the tricks that they were able to use was that the sample had to still be, quote, available. And
Right.
and so and at the end of the day, I think they wanted to conclude that there were only a dozen, bad samples.
I
And
think
that's
out of the ones that they said weren't available for testing anymore were ones that they thought could have possibly corroded over time. And instead of just testing those for the extra, I don't know, $5 or whatever it was, they're just like, oh, you know what? Could have been corroded. We're just going to take that out of the whole investigation.
I mean, one thing that could have been done would be to take all the samples and on a statistically significant sample basis, retest them and see what the error rate is. I mean, the right now in the field of science, there's a pretty bad replication. Jamie, you want to cover your ears here, but there's like a pretty bad record of people being able to replicate someone else's experiment. Right? They call that the crisis of replication or whatever. And that's when you have, like, let's call them real scientists. So if you had retested a significant number of samples in this lab, sort of cross-cutting, I think it would have been pretty alarming what was found and eye-opening, but they never, of course, did that.
So this sentence here, the results of the OIG's review of potential misconduct and retesting efforts are set forth in the supplemental report. Ultimately, the OIG found no evidence of any misconduct by any chemist other than Dukin. Person is crossed off and chemist is there.
I think that probably has to do with NASIF
Yep.
because receives
Yep.
because
That's 100% native.
yeah.
Other than Dukin. And then it says highlighted on the right in comments, I am not sure this is accurate. Didn't we make criminal referrals?
Well, it's not accurate on the face of the report, but you wouldn't know it because you remember that supplemental report was the one where suddenly the OIG forgot that you can use someone's name. So they were
Yeah,
Right,
like, a
that's
right,
chemist
right,
was
right.
right.
talking
They
to
just
another chemist, and the first chemist said, "Hey, did you see that, sample that I tampered?" And the second chemist was like, "No, I didn't." And it's like, well, who are you talking about? But if you actually know the samples, and we went through this, right? We decoded those samples, and we found out who the chemists were, and you could tell that there were samples that were where a negative was turned into a positive that didn't involve anti-Dukin. So I don't even know how on the face of the supplemental report that statement could be defended. Forget the referrals. Obviously, that's super problematic, but I'm just wondering how and I guess now we realize that it was completely intentional to omit chemist names in that supplement.
Mhm. And yeah, like when they were preparing for the supplemental report, I think we covered in an earlier episode emails where one person from the OIG was saying, we learned about the BZP issue through retesting, and also misclassifying the drugs was a pattern of malfeasance, right? So I guess they're hair splitting again between patterns of malfeasance and any misconduct, but they did say willful in the criminal referrals. So willful pattern of malfeasance. I don't know how that doesn't amount to deliberate misconduct impacting testing.
The other
Well, the
part of
problem
that,
is that two of the chemists, remind me, was it Dukin and Farrak, corresponded about BZP.
it was
Hmm.
Dukin and
They
Farrar.
weren't the only ones, though.
Right. They
Yeah, no, but Peter Piro, like, and
and so
they
they
got clear
knew.
guidance.
So they knew. And then there was a discussion about omitting Class E.
Oh,
Uh,
we talked about that in the last episode. Turns out to be a Dan Renzikowski email to Salemi, not Peter Piro. I
okay.
think
And
I
so
But
had mentioned didn't remember which one it was. I looked it back up. It was Renzikowski.
okay. And so with that, now we know that there were multiple chemists who were aware before the mandate to take Class E references off the certs, and yet they continue to issue certs that stay.
Yeah, there were emails back and forth where they're saying this is in a Class E, and then they sort of agree, and then sometime later, Renzikowski's writing to Salemi, and he's like, "Hey, we agreed that this isn't Class E. Why are we still issuing these drug certificates saying it's Class E?" But then even after that, they continue to do it.
Right. So
well,
there was,
but
I
here's the
would say
thing,
there's
guys.
knowledge.
What's that, Elias? Sorry.
I would say there was knowledge. I mean,
Oh, without
you,
Yeah.
question.
yeah.
But dude, here's the thing. Like they remember there we have those emails where they went back and forth and are like, what do we do here? Like
Hmm.
what do we do? And Nassif said clearly, report your findings and leave the law, like the classification part up to the district attorney's office. So we know what happened there. Like,
Okay. So there's one email with Nasif where she actually does say the right thing, for
right,
one, saying
she does.
this is don't put it on there, leave it up to the DAs. And
Yes.
then Salemi apparently keeps on printing these certificates that say it's still Class E. That's why Renzikowski confronts him and says, "What are we doing?" And they continue to do it after that anyway.
Well, because they left it up to the DA and the DA said misclassify it.
No,
That's
no, 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 no. So we did find over the course of many years certificates that said instead of a class, it just says whatever the finding is. It might be federally scheduled, but there are other ones that just say Class E.
Right.
so it depended on the chemist.
I think
Well,
so. I don't think we ever
it was
put
a
together a
drop down.
spreadsheet of those, but that's
Yeah.
my recollection.
My understanding is there was maybe a drop down menu. And so it would be either depending on the chemist or depending on the mood in the room, drop down menus being what they are. That you're not going to get uniform practice necessarily. But when we covered BZP, I think I asked a question, and I'm still curious of the answer. Was it lab policy to indicate in the cert what the thing was, even if it was not, in their belief, an illegal narcotic or a controlled substance? So,
I
meaning in the
think the
case of
certs differed at different times.
So in the case of my client in his one of his earlier cases where he had, well, in the case that I handled, it was cashew. But in the other case where he had, I think it was Tylenol. Did they issue a cert that said Tylenol? I'd be curious to see that. I don't think they did. I don't think
No.
as a practice they did. So why would you be issuing certs that say BZP, regardless of whether it says Class E? So I think the deception is sort of
Mm,
the same. Now, I could
I've
stand
seen
corrected if
certs that
someone,
say ibuprofen, but ibuprofen at a certain amount you need a prescription for. I think that's the
okay,
closest analog.
right. So I mean, I just am curious because it's like, why are you even issuing a cert for BZP? Um, and and I can't remember if it's federally scheduled. I guess maybe you might say, well, if it's
Well,
federally
anyway,
scheduled,
we're getting down a
yeah,
rabbit hole here. The point is, uh, they knew the lab was misclassifying things. It was willful misconduct. They made the referrals, send them over evidence showing it was willful and knowingly. And hence all the comments that are in effect, we shouldn't be saying this, that's inaccurate, about the sole bad actor conclusion.
Right, right.
And then there's another comment that they didn't discover any evidence of red flags with respect to Farak.
And they
Uh,
said this whole paragraph is really important.
right.
Yeah, that's crazy. That's I would qualify that as bananas crazy because what's his name? Michael Wolf from NMS, one of the consultants they hired, specifically sent them emails saying that Farrak's productivity was an issue among several other chemists.
Right.
So that's just clearly not true.
And they're like, this is really important. This whole paragraph is really important. They're trying to cover their butt. That's why it's really important.
Hmm.
But it doesn't add up to the evidence that they know about. So it's like even people within the OIG are confused or something. I don't know. Add footnote or add here. Or has any evidence been offered to contradict this finding? Hold on. Sonia Farak was employed as a chemist by the Hinton Drug Lab for approximately 18 months between 2003 and 2004. In 2014, Farak pleaded guilty to tampering with evidence at the Amherst Drug Lab where she had worked since leaving the Hinton Lab in 2004. The OIG's investigation found no evidence of similar misfeasance or malfeasance. Oh, there's your favorite words, Chris, by Farak during her time at the Hinton Drug Lab.
Well, that goes back to what I was just talking about, that Wolf email.
Exactly.
Let me see if I can find that. It's got to be somewhere. I don't have it.
Was Wolf with he with NMS or was he with Markham
He was.
or somebody? It was
I
I
think
thought
that's
it
the
was.
same thing.
Oh,
No,
is it? Okay.
I
I
could be
thought those
wrong,
I thought those
but
were separate, but
I could be incorrect. But
And it says add footnote here, add, and to this date, the OIG has discovered no evidence, nor has any evidence been offered to contradict this finding. They know that's bullshit. They found it themselves.
oh, NMS was, I think, the
that was
independent
the
lab
yeah, that was
that
the outside
actually
lab.
did the testing, and
Right.
then Markham had the consultants that were analyzing things and saying we need to send this to the lab, and then we'll look at it, stuff like that.
And the concern about spiking, right? That was Wolf that said,
Yeah, that was
yeah,
Wolf
yeah.
too. Let me see,
Right.
and just trying to find in my emails. Spike nefariously. That was a keyword. Let me see if that comes up. I don't want to bore people while I'm looking for this. So,
All right. So the bottom line is that there's now evidence that the OIG, members of the OIG, wanted all the cases dismissed.
right.
And and they all know, or a lot know, and everyone who read these write-ups knows that there's evidence of other chemists other than Dukin having committing misconduct. They made criminal referrals to that effect to the Attorney General's offices we've gone over before. But there seems to be arguments as to like what kind of malfeasance there was, or if it was Sonia Farak at the Hinton Lab. They really seem determined to like wish it that Sonia Farak did nothing at the Hinton Lab. Meanwhile, she was testing more cocaine than and she was a cocaine addict, and she was testing more cocaine than any other chemist in the history of the lab. So those are things that we know just based on stuff that we've seen that comes from the OIG's own investigation.
Right. Yeah. All right. I'm going to start looking for that one email. We can throw it up.
Yeah, we'll throw it up. But
But
anyways,
essentially, there were two that we were talking about. One where Wolf was saying about a particular sample, it looked like a chemist had spiked it nefariously.
what was
And
that
then
chemist's name? I can't remember.
was it?
That was in a previous episode.
Yeah, that was in a previous episode. Maybe Sasha Haynes. I
Sasha
think it is.
Haynes, that's it.
Right.
And then there was a separate one where he was saying these testing levels, essentially, I ran the numbers, these testing levels were on par with Dukins for various amounts of time. And as a result, they should be treated the exact same way because high testing numbers were a red flag for Dukin. And then it lists the first one in the list of multiple chemists is Sonia Farrick.
And she was something happened before she got transferred. They had an internal meeting and they found something, and that was right when like her numbers were off the charts.
Right.
We've gone over that in a previous episode as well.
Yeah. So
And
anyway,
the numbers thing, they mention it here it's worth reminding people that that's a little bit of a red herring. One, other chemists achieve those same levels. And two, that wouldn't necessarily indicate anything particularly wrong, right? I mean, maybe it's not possible to follow the rules and test at a high volume, but you're still looking for like actual patterns of misconduct, and I think it was convenient to say the only thing we knew about Annie Dukin was she had high levels, and yet it was, I think that there was reason to be suspicious of her and other chemists, and that was the only thing they could articulate was, oh, it must have been the red flags of her high levels. And yet there's very poor documentation of those concerns prior to the May and June breach. So I
Right.
always think that they always retreat back to the high testing volumes as their way of explaining how this thing unfolded. And I don't personally buy it, but I note that there's very little documentation that's contemporaneous about that.
Right. I mean, it's the changing the negative, the positive, forging people's initials, like just a wanton desire to mislead and misrepresent, lying on the stand, like, but she relished her role as being the go-to person from of the prosecutors. At least Dukin did, but they all did. They all celebrated when they got emails from the DAs that the cases that they were testifying in, came back with a guilty or a stipulation or whatever. They loved it. They were all on the prosecutor's team. All right. Um, okay, I guess next time do you want to go over we were supposed to go over what's her name's
Julianne Nassif's
Julianne Nassif's
interview with
wonderful
the
pleading the
OIG where
fifth.
she takes the fifth 25 times.
Yeah.
Yes.
We'll do that next time. This one was great. So,
Impromptu because it was breaking news.
yes, exactly. All right, guys. Anything else?
That's it. Thanks.
All right. Thanks. We'll see you again real soon.